Hello and welcome to another episode of the Property Playbook. I'm your host, Peter Carlseen with Paracelsus Property Management. I am a licensed real estate broker here in California, and I am visited by a couple of my great colleagues, Dale and Kevin. Thank you for being here with Ted Smith Law. Real quick, tell me a little bit about yourselves, maybe 30, 60 seconds. What got you into what you do and what gets you out of bed in the morning?
Oh, so I've been doing this full-time since 2020. Ted Smith, who founded our business, he passed in 2020. So I had been working part-time for him for about 2 years. So I took over the business. He had been doing it since 1976. So yeah, Ted Smith Law has been actively working in landlord-tenant law since the 70s.
Excellent.
And I've been working for Dale for about the last 2 years. I graduated from the University of San Diego School of Law and passed the state bar exam. Now I'm waiting for my background check to clear. I guess I'm a little bit sketchier than I thought. So that should come out any day now. And I love doing landlord-tenant law because I love learning about all the properties and all of the neighborhoods and everything around San Diego. It really, you want to know what gets me out of bed in the morning is that I get to live in the most beautiful city on earth. And I like to learn about the people who live here and the places they live in, and then do my part to help them have a good time.
Excellent. Sounds good. I'm going to ask you a weird question. If we were to open up your Netflix or Hulu account, what are we most likely to see on your queue?
What my mom watches.
Dude, I watch old weird historical stuff. Like there's this one about the czars of Russia, like just before the Russian Revolution. But I'm also into like a lot of comedies, like Going Dutch just came out for this second season.
Gotcha.
Yeah.
Nice. Okay.
Or RuPaul's Drag Race.
Oh, there you go.
That's
That's a good mix of stuff there.
It's better than politics.
It's better.
Definitely.
It's better than politics.
So no Law and Order, no Criminal Minds.
Close.
Couple of decades. That's an old reference right there.
It's too close for comfort. I don't want to like that.
You live it every day.
Yeah, I live it every day.
Awesome. Well, I have you on here because we want to talk about a lot of the new laws that are affecting landlords here in San Diego. So one of them that I definitely want to go over is when it comes to security deposit restrictions. We're seeing a lot of it's changed a lot over the years. Where are we at right now with that?
So we're at there are some exemptions. The thing is, I would stick to the red letter of the law because it's 1 month's rent. That's it. That includes pet deposit. That includes everything. So it's 1 month. So if they have a pet and you usually had a pet deposit, you can't ask for a pet deposit anymore. You can't ask for pet rent, but you can't ask for a pet deposit. So it's 1 month strictly. Now there are some exceptions, but if you have to do an eviction, you don't want them to nitpick on do you have the proper exemptions? Do you have do you qualify? Do you have exemptions out? So I would just stick to 1 month rent. That's it.
Keeps it easy.
Yeah.
And make sure that you do a pre-move-in walkthrough and take photographs of what the unit looked like before and after any maintenance that you do. And then when they move out, make sure that you do have the move-out walkthrough without the tenant's belongings in place. Call out everything that you plan to deduct from their security deposit, and make sure that they have an itemized list of the things that you want fixed before they actually move out.
Right.
So you get them you get at move out when you give them the security deposit, accounting and everything.
Right.
You may have to give them pictures of the move in, the move out, or the pre-move out,
right.
The move out, the after repairs.
Correct.
So they got like a whole hard drive worth of visuals.
Correct.
That they're
right.
Okay.
Correct. And if anything, this definitely protects landlords. We've seen a lot of cases where an individual will say, "Well, I didn't do that. That was like that when I moved in." And if you've got the photograph that says, "No, that was definitely not like that when you moved in," the judge is going to side with the landlord every time.
Got it.
Yep.
So documentation is key.
Absolutely. More documentation is always better than less.
Absolutely, especially if you're making repairs because you're going to need this at the move out. So if they complain about, oh, my sink's leaking, go and take pictures before, take pictures afterwards, make sure you show, even if you want to take video of it running and it not dripping, or, you need to be real careful about this because what I'm seeing is that a lot of tenants are going in, paying the first couple months of rent and then saying, oh, well, I have fleas, or I have rodent problem, or I have a the door doesn't lock, and it's like, you need to do. If you have pictures and say, here's the door locking, here's, making sure the door's locked, so that they don't come in, because it seems to be a lot where they're going in for a couple months, paying the rent, and then deciding they're just going to,
and then there's
uninhabitable.
Yeah.
When you ask, you give them a 3-day notice to pay rent or quit, and they're like, oh, well, no, there's issues.
All of a sudden, that's when you learn about the habitability stuff.
You're like, oh, really? And, and especially because I had one who they kept saying it was uninhabitable. I kept telling my client, you need to go over there and look and take pictures.
Yeah.
Turns out that they had taken a hammer to the roof, and that's why the roof was leaking. Yeah, so you want to make sure if you crazy. If you go in there, you make sure, he said, I just repaired the roof in February. I'm all, they're saying the roof is leaking, and then comes to find out, yeah, the roof was leaking because they had taken a hammer and smashed it.
Wow.
To make it uninhabitable.
So you definitely want to, when those issues come up, you want to knock them down as soon as possible.
Absolutely.
Right.
Okay.
And, if they call and say, oh, something, the worst is like if you have a flood. Not your fault. Floods happen.
It happens, yeah.
But make sure that you take care of it immediately, that you, it's like, you get that, you don't want them crying mold, because that's the first thing. We live in San Diego. Most places have mold, mildew, and they're always thinking that mold and mildew are the same thing, and it's not the same thing. So make sure you go in there, you have water tested, saturation in the walls, you take that care of that. Even if it costs the landlord, and like, even if you have to move them out for a couple of days, and it used to be per diem. And now they're getting to the point where it's like, it's not per diem anymore. You have to actually put them up in a place and pay for that, not just say, oh, here's your $100 a month or whatever the daily rent is. You have to put them up in a place until it's cleared. And so you want to make sure you take pictures of when it's before, after, during, everything, so that you make sure you have documentation, because I've had so many tenants saying, oh, well, it wasn't fixed, and now I have mold. And even though it's been remedied, they're still complaining about mold.
Yeah, I totally understand that.
And on mold, watch out for what they'll try to say about mold. You cannot diagnose mold legally by smelling it, by looking at it, by feeling it, anything like that.
Tasting it?
By tasting it, hopefully not. But you need to have at least one of two tests done. One, the air quality test, where they take the Petri dish and measure the mold that is in the air, and also the swab test, where they swab the area and do a DNA test on that. The little home test kits that you can buy at Home Depot, those are never going to hold up in court.
Nope.
So if you do have a complaint of mold, make sure that you get a licensed contractor in there to tell you what the mold is, and then you will have that to protect you when you do get to court and say, yes, we did do this inspection. This tenant claims that they have respiratory problems or something from mold. That can't be possible, because, as you'll see right here, there is no mold actually in this unit.
Exactly.
Yeah. Mold it's their biggest complaint. It's like they see they don't clean their showers, and now they're screaming mold. It's like, well,
it's absolutely. It's a total grift.
Yeah. Now, you brought up earlier in the conversation, you brought up exemptions, and I want to make sure we touch on that, because there's the statewide Tenant Protection Act. There's the local municipalities have their own tenant protection ordinances. What's this exemption thing? What are you talking about?
100%. If you are exempt from AB 1482 or the San Diego Tenant Protection Act, you need to make sure that your lease contains the language saying that you are exempt. If you call our office, we can always review the lease for you and make sure you have the proper language in there. If you do get into a situation where you need to do a no-fault just cause eviction or something like that, that's going to determine whether you owe that tenant 2 months of rent free, or you get to just not owe them any money at all. So it is very, very important for every single lease after 2020 that it has the correct language in there to say that you are exempt from AB 1482 and the San Diego Tenant Protection Act. If you need any assistance with that, we advise you please call our office, 619-610-9332. I would be happy to go over any lease with you and make sure that it's in there.
So,
perfect.
And that includes all of San Diego County is under the Tenant Protection Act of 2019, which is the state one. The city of San Diego has a separate one. It's the Tenant Protection Ordinance. So if you are a single family home, you're not owned by an LLC, a corporation or what's called a real estate investment trust. If it's a regular family trust, you're fine. And then you're exempt, and you need to have that in your lease. There's also the Imperial Beach and Chula Vista municipal codes. So those are the four. So it's either the state, the San Diego City, Imperial Beach, or Chula Vista. Those are the four that have. The nice thing about Chula Vista is that you do, if it's a no fault eviction, you register if you have a 30-day, 60-day notice, 90-day notice, you give it to them, they register it. I haven't had any problems. But if you're exempt, you make sure that you have it in your lease. If it's not in your lease and you're like, I qualify for an exemption, it's not in your lease, it's waived. The only way around that would be to get that exemption out in a separate lease. So if they're on a month-to-month,
Okay.
then just offer them a new lease. Don't I would be careful about raising the rent or anything. I would just say, hey, you're on a month-to-month. We want to get you onto a lease. Here's a new lease. Can you please sign it and have that exemption in there? If they don't, unfortunately, if they don't sign a new lease, you've waived your exemption. And that's what I've seen when these laws went in. A lot of small landlords call me up and say, oh, I wanted to get them out and I'm exempt. I'm all, did you give them the exemption? And they didn't. And now they're not exempt. And that includes, so if you're exempt, you don't have to follow the just cause, no fault, at fault, which means you have to give them a reason and has to be a acceptable.
A specific acceptable.
Specific,
Yeah.
Specific acceptable reason.
Yeah.
Or it has to be a 3-day pay or quit. So if you're exempt, and then you have to give them rental relocation.
Yep.
So depending on which one it is, you get either a month or 2 months. Or if they're over the age of 65, they get 3 months. And if they're on, Section 8, they get 3 months. They get a 90-day notice. And so it's just really need to, because if they're considered disabled, then and that's the reason, then that's a 3 month.
Yeah.
3 months rental relocation. So if you're exempt, you don't have to pay their rental relocation. You don't have to give them a reason. You can just say, hey, I feel like terminating month to month, or at the end of your lease, we're done. I don't want you to be there. But unfortunately, if you don't have that in there, then you have to give them a reason. You have to give them rental relocation. And the issue would be if it's terminates, it's iffy on if you can just say, hey, the eviction's terminating, we give you a termination. In San Diego City, we're not sure if you can give them a termination of a lease. Say, hey, your lease is terminated. It would be a lease violation, and then you have to give them a 3-day to cure to move, and then you have to give them 60 days. So we make sure you have that exemption in there.
So if your paperwork's not good, and you can't just write exemption at the top of the paperwork.
Yeah.
No,
I claim the exemption.
That's in the legislation that has to be in there.
Word for word, symbol for symbol,
Exactly.
everything. in at least 13-point font or something.
Yeah.
12
Right.
12 point
12 point.
underlined, and some of it has to be underlined.
Yeah.
But also, the other thing is that the Tenant Protection Act, not only does pretty much every lease needs to have the Tenant Protection Act in there, whether you're exempt or not, because it talks about how much you can raise their rent. So if you are exempt from the Tenant Protection Act, which is the state one, and all of the cities are under the state rent control. So if you can only raise the rent 5% plus CPI, which at this point it's 5% plus 3.6, and it changes every April. So whatever the CPI, the consumer price index goes up, and you're locked into the April date, but it doesn't go into effect till August.
So it revises once a year, and
once a year, yeah. So
based on the county inflation numbers,
yeah. So it's at a maximum of 10%. So if you have that Tenant Protection Act and you're exempt, you can raise your rent to any old thing you want. But I mean, within reason. I mean,
with proper notice and
reason,
yeah.
And if it's over 10%, you have to give them a 60-day notice. And if you're trying to bring up a property because it's really low, then you're going to be exempt. You're going to be like, say you just bought this property and you want to raise the rent, but they're at like $1,000 a month for a 3-bedroom house, because the other landlord didn't care, but you want to raise that up to what it can be. It should be. You're going to be, unfortunately, under a bad. You're only going to be able to raise it 8.3% or 8.2%.
Yeah.
So
you want to make sure you get those exemptions in the lease paperwork up front, so that way you don't have to worry about a lot of these other headaches. I've heard of military service members coming back to want to move into their own house.
Yeah. Oh.
And if they don't have the exemption on it,
Yep.
then they're paying the tenant 2 or 3 months worth of relocation allowance just so that they have the right to move into their own property, which sounds ridiculous.
Right. And definitely contact a local attorney. You'll see a lot of form leases and whatnot online that say, "Oh yeah, we're completely compliant with California law." And they mean AB 1482. They mean the state law. And don't realize this property is in Chula Vista. It also has to have the Chula Vista exemption language in there. So definitely don't go into it blind. Get somebody to help you, who can make sure that every I is dotted, every T is crossed, and it's being done for the right zip code.
And plus, most of my clients have 35 to 70-page leases because they have all the addendums. You have to have the mold addendum.
Bed bug addendum.
The bed bug addendum, the flood zone, the lead-based paint, all that kind of stuff.
Yeah, so it's like, I'm looking at why a 70-page lease? Then I have these clients who their tenants have been in there. It's a single-family home. They have a
1 or 2 page lease. Yeah,
exactly.
Yeah,
from 1995 or something.
if even that. Yeah,
I had one from 1995 a couple of months ago. It was like,
oh no,
this is out of date.
Yeah, it's like even if they're on month to month, there's good things and there's bad things about leases. So, but you can always do a 6-month lease. Mm-hmm. If you want to get somebody in there, you're not sure if they're going to be the right fit, but you want to do a 1-year lease. I know some people do a 3-month lease just so that they can see if they like the person, and if not, then they can get them out at the end of the lease.
Got it.
Yep.
So what happens? Actually, I want to talk about pets and service animals. Yeah, because that's starting to get to be a big deal. We have a lot of my properties that I've managed. A lot of them were no pets. And so when this service animal or assistive animal thing came out, it was a big shock to a lot of owners. They're like, well, I said no pets. Why do they have an animal? And, well, it's because it's either an emotional support animal or it's a service animal. Right. And, well, what's wrong with the person? I can't ask them what's wrong with the person. That's not...
What you can absolutely do is ask for a doctor's note signed by the doctor on the doctor's letterhead that says that this person has been prescribed an ESA. They won't go into the detail on what it is. And, some of them look really professional. Some of them you do look at and it looks a little sketchy. Dale likes to talk about emotional support puppies. Like, how exactly is a puppy running around chewing your furniture? I'm supposed to be emotional support.
I just don't get it. How, if you have a puppy, that's not emotionally supportive. That is a little demon.
Yeah. It's a full-time job.
Yeah, it is a full-time job. I just don't know. When people I'm like, oh, they got an emotional support puppy. Okay. And you're also, you can ask them for the medical records of the animal.
Yes.
You get shot records. They have to have that, all that.
Yeah.
And you can even ask them to get a letter from the vet that says that this animal is non-reactive or not.
Okay.
And the thing is that they have to follow the law. So if they're not picking up after their animals, and then but a service animal, they just have to show you the badge, the registration. That's, you can take that dog, that pet, crow.
Have you seen any bizarre support animals out there in your experiences?
Japanese quails.
Oh, that's specific.
Very specific. There is apparently a difference between a Japanese quail and an American quail, and the Japanese kind can be domesticated and the American cannot. How it does service, I have no idea, because it's still a little bird about that big that I don't know really what it does. But yeah, let's see that.
All right.
Birds.
Lizards. Okay.
Absolutely lizards.
I'm like, I want to get emotional support sloth.
Yeah. Okay.
You know, but it's the ones that it's like, you know, my thing is the people who get them and they get emotional support puppies and they're barking all day and it's like, aren't you, that's your emotional support animal and you're supposed to have it with you all day long. How are you going to work?
Mm-hmm. That's a great question. Yeah.
You know, if you need it and you had to have it and it's something or if you're your child, well, shouldn't your child be taking that emotional support puppy to school with them? I mean, the school has to let them in. Them leaving, they're getting the dog because they can.
Yeah, that's right.
And because
Found a loophole in the law.
And they'll get it off, dial a doctor, and that's why you need to make sure that you check the doctor. I've seen them. It's like, we're not taking. It has to be from the state of California.
Yeah, it's got to be California.
It used to be Hawaii and Alaska, and all that they would get these letters from online. You know, get your.
There's a lot of that going on.
Yeah. Yep. So I check them.
Mm-hmm.
I'm like, if it looks shady, check and see if they're registered in the state of California, because there's a therapist registry for them. So and they have to be seen. You can't have been seen, you know, within the last 6 months. Again, take a year ago, and I've asked for a new letter every year.
Yeah,
you know,
that's fair.
You know, there's nothing as long as they're not. You don't ask them what the disability is.
Mm-hmm.
You can't. So you just. But the doctor's note says that they have a qualifying disorder or
diagnosis.
Can you ask them to be specific on the notice? Like, is it they need emotional support animals? Well, how many do they need? Or
you can get them to actually name and identify the animal that is in question. So they'll say, yes, we're prescribing a 3-year-old poodle named Johnny or something like that, and get that specific.
Okay.
Yeah, you can, and then you ask for the health records and the doctors saying that this animal is non-dangerous, because that's an issue. These people get animals that are not well watched, and they sit at home and get bored and they're destructive. So
problems,
So but they have to follow the law. So if they're leaving and their dogs are barking all day, you can always call animal control and say.
That's right. If a person was barking all day and causing a nuisance, we'd call the authorities on them. If someone's not picking up their stuff in the yard, it's a person, it's an animal, doesn't matter. It's not supposed to be there. Yeah,
you
can call them out on that and enforce that. Yeah.
Especially if it's working all day, because
yeah. So let me switch gears over to let's talk about appliances a little bit, because that's been a recent change in
as of January 1st this year. Yes.
Well, we'll quick back to the emotional support animals. I know that this is hard for landlords to accept, and I understand, because I don't want some rando dog that I don't know how it's going to behave, peeing in my house or whatever. But the thing is that you need to allow it, because of the fact that you don't want a housing discrimination case. Yeah. Because
how bad can that be, really?
$40,000. I settled one for $40,000. Settled.
Yep. Wow.
For $40,000.
And the paperwork involved is immense, absolutely voluminous.
Yeah, you.
How many hours do you think they wasted dealing with that?
Over 100, at least. Hundreds would be a conservative estimate.
Yeah, it's you don't want a housing problem, and it's like people are like, well, I have a single family home and I don't want to accept like Section 8 or ESA. I'm like, you do not want to have a housing problem.
Yeah, you don't want to have a rental property in California if you don't want to have that, because you could be really setting yourself up.
And this was a small fourplex, and they said they didn't actually deny her because of the pet. She said that it was just really, it was like you weren't denied because of that. You were denied because you weren't qualified, but they said that they denied her of the pet, and so $40,000.
So it's critical, and this is a conversation I've had with my clients. If we're not renting to see who is the best fit per se, we are renting, and as we get applications, can we deny them?
Yeah.
It's not can we accept them, it's can we deny them, and do we have legal basis to deny them? If you don't, then yeah, you're opening yourself up to a whole slew of potential issues.
And you do not want a housing issue because they don't pay anything, and the government is coming after you and it'll go, and I'll have them go, and I'm thinking everything's fine because I haven't heard from them in 90 days. They're like, and they'll send me a letter. Oh no, this case is still open.
Yeah.
And keep doing that.
So over the course of months, you've got that in the back of your head as an owner that you're dealing with. It's just a ticking time bomb.
Yeah, you do not want a housing problem.
Yeah, and we've seen them. I mean, we've got a few going on now, and it's so easy to file a complaint that we have definitely seen some that were definitely intended to harass the landlord. Somebody didn't get their way, and so I'm going to go to the state and file this completely facetious complaint, and it goes absolutely nowhere. And 100 hours later, nothing has come from it. They look at, okay, so I guess nothing really happened here, but still that process that the landlord had to go through.
So how does the landlord protect themselves so that they're not in that situation?
If you ever receive a reasonable complaint accommodation letter, definitely call us or another landlord's attorney, and we will take it from there and respond to it in the very specific language that we know how to write, so that the state will keep it as simple as possible, and have as best an outcome.
They can't find that on Zillow or LegalZoom or.
I would highly suggest not doing that. No.
Yeah, because it's
ChatGPT.
Because they have a lot of, and some of my clients are like, sometimes it's like, did they set them up for that? You know what I mean? Did they send this woman and go, oh, go check and see, because it's just so.
People would do that?
Yeah.
I'm shocked.
Yeah, I know. The horror.
Exactly.
But no, people are, because housing is so difficult to come by, and people, they're looking for any excuse to.
And in their defense, to some degree, there are some scummy landlords out there that take advantage of their residents, that take advantage of tenants, that openly violate the law. And there's got to be, there needs to be some sort of accountability. But if your intention is to do the right thing, that follow the letter of the law and keep yourself out of trouble.
Absolutely.
Talk to an attorney when you have to. Whenever there's a question. Yeah. Or anything like this comes up, talk to an attorney that knows what they're talking about.
Because you don't want a fair housing problem. You don't want to have issues with them, them not paying you, and it's because they say it's uninhabitable. We want to make sure, as we were talking about, take pictures, make sure everything's taken care of, make sure that they don't have any reason. Documentation.
Of course.
Working with the animals, make sure that. If it is an ESA, make sure you get your correct documentation. If you have any issues, make sure you have the correct documentation. And if you have any questions, don't try to deal with it yourself, because even when we go to landlord-tenant, the unlawful detainer judge is like, this is very difficult. If you were representing yourself, there's a lot of nuances, and there's a lot of different laws that we're juggling. So just make sure even if you call my office. I don't generally charge for phone calls. If you want to give me a call, we'll talk about something, just because I'd rather you have call me or their property management company, or somebody to make sure that they're in the right direction. Because, people, I know a lot of them would say, I knew I was exempt. I didn't know I had to have them sign.
Right.
Or give them that, and so just better to ask there's no stupid questions. Even unless you ask me 6 times, and then it's a stupid.
Yeah.
And it's better to ask what you think is a stupid question than to be stuck in a situation where it's like.
Yeah. Swallow your pride. Yeah. Ask the stupid question. Feel dumb for a few seconds, and save yourself $40,000 in legal fees.
Exactly.
Yeah.
Exactly.
Yeah.
Yep.
Cool. Let's go over to appliances real quick.
Yep.
New law. Landlords have to provide working stoves that heat food properly and safely, refrigerators that cool food properly and safely. Do you see this affecting the market at all? Like, have you seen any run-ins with this or any issues?
Really, I'm going to say no, at least not in San Diego. Now, that's a state law, so that might be addressing a problem in some far-flung county, I don't know. But we really don't have any clients that don't already have stoves and refrigerators that work in their units. And also remember that the tenant can opt out. You can get the tenant to sign a waiver saying that they're going to provide their own stove, their own refrigerator, etc., that they're able to opt out of that requirement as well.
Got it.
Yep.
I haven't seen it. I mean, most people have it.
Yeah.
You supply it, especially if it's a big complex. But it's a single family home. But I understand that if you're moving out of your single family home, you may want to take your refrigerator with you, but you got to leave it there.
You got to leave it there. I saw it a lot during when we had the housing crisis back in, 2009, 10, 11. There's a lot of foreclosures and short sales.
Okay.
People were, losing their homes, but they were taking their appliances because that was like they were attached to those washers, dryers, and refrigerators. Like that was theirs.
The homeless with a refrigerator.
Yeah. So I saw it more than nowadays. I don't see it too much. And when they tried to pass the law, like right at the end, they took out that stipulation that says it has to be, 10 years new.
Right.
Yeah.
Thank goodness, because otherwise there'd just be a whole bunch of stoves and refrigerators out there that work.
Exactly.
All kinds of wastes.
Yeah, it's in because especially old ones. I mean, especially if you have like really old ones, those things last forever.
I saw a post that somebody put out there. They said, "Hey, let's do this. Let's take all the patents from the refrigerators from the 50s, and let's just make them like that again."
Yeah.
So
we don't need all this water like touch screen TV. Because I had a keg. I was in my 20s. I had a keg refrigerator from the 50s. That thing was never gonna die.
Yeah, they're built to last.
To this day.
So, kind of switching gears now. If somebody has a tenant that's not paying rent, and I see a big difference in if it's professionally managed versus if it's self-managed. What are people? If you're self-managing, you have no idea what to do, and you're like, oh, this guy, he told me last week it was going to be in, and it's been a week. What's your advice on that?
Call us immediately. And here's why. For a couple of reasons. If you give someone an inch, they're going to take a mile. If they say, I'm going to pay you by, next Friday or something like that, and next Friday it's going to be like, well, no, I'm going to pay you by next Tuesday or something like that. And there's just snowballs. So call us immediately. You definitely want to have a professional write the notice for you. And here's why. The notice is a very, very formula-driven, statutorily driven document that has to include very specific languages. You have to put on it the date that it expires. So if it's a 3-day notice, you say, okay, well, it expires in 3 days. Well, what does that mean? Not including the date of service, and goes up to the midnight of the third day. So, for example, if I served it on somebody today, on Friday, it would not expire until Monday, Tuesday, Wednesday of next week at midnight.
Unless there's a holiday in there somewhere.
There's a holiday in there somewhere. If Monday was a holiday, then it would be Thursday. And you got to make sure that it has a physical address where the tenant can go and pay in cash. It has to say when there's somebody going to be there to accept that cash and what their name is, and a phone number where they can be reached. So there is so many little I's and T's that have to be dotted and crossed that are required in these notices that you really want to get a professional involved at that point, and have us write the notice for you. We write the notices for $195, and then if you want us to serve it, it's another $80. That's a lot cheaper than getting you all the way to a hearing and finding out at the hearing that you made a clerical error 3 months ago, and now you're back at square one.
We're back at square
So
one.
definitely get a professional involved at the very start, and we'll make sure that it's airtight and it's going to hold up in court.
Yeah.
So if somebody's pulling a 3-day notice off of the website, and they're like, hey, everything's on here, it's legit, but they forget something as dumb as
the expiration date.
Date.
That is actually a new law that came out.
Yes.
That's a case law that came down about the spring of last year. So a lot of the templates you see online don't actually include that at all yet, because they're from only 1 year ago or something like that.
And the other thing is that don't get in a pattern of behavior. And I know this is really, if you self-manage, God bless you, but Um, be really careful because you're going to give them. Oh, well, them pay late this time, and then let them pay late, and you get in. Well, then they're thinking that they don't have to pay till the 15th. They don't have to. So then they get in their pattern. Well, you let me do it before. Why aren't you letting me do it again? So don't give them any leeway. Even if you have to, I'll give you a day or two. Like usually in the lease, it's 3 to 5 days.
Sure.
So,
Yep.
if you don't pay by the 5th, give me a call because you don't want them getting, well, I paid them late before, it's like, there's nothing wrong in giving them a notice and then, them not, then them paying, fine. Okay, good.
Then it's settled. You
Then-
don't have to
then
worry
it's
about
settled.
it. Yeah.
But if they don't, then you want to make sure, and let me stress this enough. An email and a text message are not proper notice.
What?
I know.
I was going to ask you about that next.
Shocking.
So somebody goes through and they're like, I got the perfect notice. It's got everything right on it. I've got the expiration date. I've got the amount. I've got the dates that it was for. I've got their name spelled correctly. I've got the property, done correctly. And I dropped it off at their door.
That's perfect. You drop it off, you post it on the door, you mail it.
Oh, you got to mail it
Yes,
too.
right.
Yeah.
Ew.
If you either hand it to them or post and mail.
Yeah.
Post and
Yeah.
mail if you don't hand it to them.
Yeah.
If you always go to the door, knock on it. If they don't answer, post and mail. It's best to hand it to them personally. But if not, don't send them an email. You can send them post mail and email.
Sure.
Send them post mail and a text message. Post mail, email, text message. But don't forget they have to have the paper copy. Somebody's like, well, I sent them an email. And
Doesn't count. That's not legal proof of service. Yeah.
it's not, yeah.
Yep.
Yeah. What I've done in my practice is when I drop them off at a door, I'll take a picture of it on the door.
Yep.
I'll text the person, not so that they know, so that I know when I dropped it off. Because if that ever comes up in court, well, what day did you serve it?
Exactly.
I know exactly when it is because I've got it
But
documented.
going forward, you've got to put the date that you served it on the actual notice.
Yes.
And the date that it expires.
Exactly.
And one thing that that trips people up a lot of cases that we get, and you have to start them over. Once you post the notice, once you mail the notice, do not accept anything less than the full noticed amount. So if somebody owes you $1,000 and you accept $500 from them, and they say, "We'll get you $500 more tomorrow," your acceptance of that $500 actually negates the 3-day notice itself. So if they don't come up with the $500 the next day, you're back at square one. You have to serve them a whole new notice and go 3 more days to get your full money back. So don't accept anything less than the full amount if you do post a 3-day notice.
Definitely. Yeah. And I've seen that a lot where people are self-managing. Oh, they just Venmo it to me.
Yeah.
Oh, they just put it in my account. So
Venmo, Zelle, all that sort of thing immediately.
So they get that 3-day notice
Yep.
and they drop $5.
$1.
Yeah.
Yeah, $1, $5 in the account.
Yep.
Penny.
Yeah. Oh gosh.
How do you Venmo a penny?
You mean the notice has to be exact to the right penny?
And to the right penny. And also, the other thing is that, don't turn off your Venmo, block them from your Venmo, because a lot of people do Venmo.
Yeah, that's right.
Yeah.
But also, it has to be delivered in person, and there's usually either notice deliver in person only, or you can mail it, because then they'll say I mailed it on the 3rd day, so you're not going to get it for the 6th day. So make sure you tell them please drop off personally.
Got it.
Or if you accept Venmo, but if they do like a penny or half of it and it's not the whole thing, then you can always send it back.
Oh, okay.
Always
Okay.
send it back.
Say, no, I don't accept this. Give me the full amount. And
Yeah, you can always send it back. But if it's cash, it's a hard, don't give them a receipt. Say, oh no,
yeah.
accepting this.
So-
There's the 3-day notice. It's just they get crafty.
They do. Yeah. So get it done right. Make sure it's enforced correctly.
Yeah.
And if you're ever in that situation, if you're not having it professionally managed, call the attorney. And even when it is professionally managed, usually we're calling the attorney,
Yeah.
because we want to make sure that that everything's set up.
I know. And I know when you call, I know it's going to be important because you usually don't call unless it's important. You're not one that I get a phone call every day. Just a quick question. It's a good question. Because I don't charge for phone calls. So
if people wanted to get a hold of you, Dale and Kevin, what are the best ways for them to reach out to you?
Okay, our phone number is 619-610-9332. It's we have a receptionist. Her name's Jessica. She's lovely. Be nice to her.
Please.
Or I will not be nice to you because she made my life so much easier. So be nice. And then we also have an email. You can always email your questions. We will respond within 24 to 48 hours on our emails. It's evict, EVICT, at tedsmith.law. So EVICT at TEDSMITH.LAW.
Awesome.
Yeah.
It has been great having you on. I'm going to have you back one of these days. There's so much more that we can go over. But I really appreciate your time helping to make my clients a little bit smarter and hopefully helping some of the other people out there that don't use this get a little bit smarter and maybe.
Well, I have to say, working with him is a blessing. He's great. I love working. If you could actually say the.
Paracelsus Property Management.
Yeah. Now, after I practice it forever. But yeah, you're one of my favorite clients.
Oh, thank you.
Anytime you want to have us back, we'll be back.
Awesome.
We love working with you.
We'll get it set up. Thank you so much.
Thank you.
For my listeners, make sure you hit like, hit subscribe, check out some of our other episodes that we've got out there, and make yourself smarter. Make yourself the smartest person in the room. Check it out, the Property Playbook podcast. Have a great day.